A lot has changed since the Kenyan cases were taken before the ICC on the 15th of December 2010. From the Ocampo 6, the list has shrunk to the Bensouda 3.
Please be seated. Veuillez vous asseoir.
Charges against 2 suspects were not confirmed, and charges against 1 more have recently been dropped.
My own assessment is that the problems that Fatou Bensouda is currently facing arise out of a less than competent job on the part of the prosecutor of Ocampo and out of certain political decisions that he made.
So would it be correct to argue that the Kenyan cases before the ICC are crumbling?
I would not rush to make that conclusion, although from a legal perspective, one would want to go with what the prosecutor is saying.
And the prosecution believes in the case of Uhuru Kenyatta that it still has a strong case to sustain the prospect of a conviction in the end, despite the withdrawal of the case against his co-accused, Francis Muthaura.
They said, we think that even if you took the view that you need an essential contribution to the plan, removing one person does not mean you're taking away the liability of the other, because the contribution is different. The allegation against Uhuru, the conclusion by the pre-trial chamber was that he provided logistical and financial support.
The judges, however, subtly alluded that perhaps it would be prudent for the prosecution to have a minor alteration to Uhuru's charges, to read indirect perpetrator instead of indirect co-perpetrator as it currently is, to improve their chances of success.
I think that Uhuru's lawyers are perhaps under instructions to buy time, and going back to the pre-trial chamber would buy them Uhuru up to 1 year. But it's a dangerous game in the sense that the prosecutor, who in my view I think has a weak case, it's an arguable case before the trial chamber, would have an opportunity to strengthen the case.
But before the prosecution could forget the damage caused by witness 4 in the Uhuru Muthaura case, another witness in the William Ruto and Joshua Sang case has also recanted his testimony.
So the withdrawal of one witness, depending on the circumstances, could fatally undermine the case, just as in the case of Muthaura, but not in all circumstances. One could withdraw, but they were making what is not an important point. Perhaps there are other witnesses or other sources of evidence that prove the same point that this witness had been selected to do.
Musila argues that given the trial is set to begin on the 28th of May, perhaps Samuel Kimeli Kosgei, who has since recanted his evidence, was not an essential witness. Kosgei, however, mentions something that raises eyebrows, that he did give interviews to one minor Kiai, among other agencies, when it is known that the ICC collects its evidence only through international and local agencies, in this case, the Waki Commission and the Kenya National Commission on Human Rights.
So those are the only routes that I can contemplate through which evidence was channeled. So to mention an individual in a case such as this, I find it quite curious. It may well be that there was an occasion through which he was approached or he gave evidence. I mean, how would Maina Kiai, for instance, know this individual is a witness?
All the same, the happenings around the ICC witnesses is raising more questions than answers.
There's a pattern emerging. There's a pattern that shows either that these witnesses were indeed induced to testify by those they claim they were. They were perhaps seduced by the prospect of living a good life in a European country to lie, and you cannot rule that out. But it could also reflect that there are powerful forces at work to undermine the ICC cases.
That, however, remains to be proved, but prosecution claims that is the case.
Remember that the dropping of charges against Ambassador Muthaura has no reflection whatsoever on his guilt or otherwise. The reasons given by the prosecutor for dropping the case, in my view, read like frustration. I'm frustrated, I can't proceed.
And according to the international criminal law expert, these Kenyan cases could largely define the future of the ICC.
Given the history of the ICC and where it is, given that it is the first time that the prosecutor was activating his power to start investigations. In other cases, it was the state making referrals or the Security Council, that I made the point that the Kenyan cases would make or break the ICC. If they all collapse, we will need a major audit of how the court works.
Sylvia Chebet, Citizen Live at 9.